All right, good afternoon. This is Division 2's calendar today. And let me just introduce you to the division. I'm Judge Ashby. I'll be presiding today. To my right is Judge John Daly, and to my left, Judge Joanne Vogt. And we have two cases on the docket. First up is Lanny versus Board of County Commissioners. And can I just ask, are the parties or whoever's going to appear in counsel in the marriage of Lama also present in the courtroom?
Yes, Your Honor. I'm counsel for the appellee.
Okay, so we don't have everybody yet, or we do?
Yes.
Okay, because what I'm thinking we might do, well, it looks like it's set at 2. So it doesn't look like we'll need to take a break in between the two. We'll go ahead and just kind of flow from one to the other. All right, so in the Lanny case, counsel, you've had an opportunity to see the rules and procedures related to oral arguments. Any questions about those? And just a reminder that we are live streaming today, so if there's anything confidential that you don't want out in the public sphere, just be mindful of that. And if everybody who's in the courtroom could actually turn off cell phones, sometimes they interfere with our video equipment and audio equipment. Otherwise, I think we're ready to proceed.
May it please the court. I'm Britt Clayton with Riley Carlock and Applewhite, registration 15940, appearing on behalf of the Lanny family. This case involves two disputed elements of the residential classification statute, CRS 39-1, 102-14.4a, the common ownership element and the used as a unit element. I believe the common ownership element is sufficiently addressed in the briefs. Moreover, because the common ownership element is undisputedly satisfied for tax year 2016, it's necessary for this court to address the used as a unit element regardless of the outcome of the common ownership element. So unless there are any questions from the court on the common ownership, I will address today only the used as a unit element. As noted in our reply brief, our main argument on the used as a unit element can be reduced to a syllogism. The first proposition is, if the two parcels owned by the Lannys were instead a single parcel, 100% of the land would satisfy the used as a unit requirement because there is a residence on the land and no non-residential use. In addition to the arguments in our briefs based on Geierman and Farney, we recently recognized that this proposition is even more fundamentally established by this text of section 102-14.4a. We've been focusing on the first sentence of the statute, where the used as a unit element appears, but the last sentence is really important too. The last sentence says, the term residential land does not include any portion of the land that's used for any purpose that would cause the land to be otherwise classified, with a further exception for bed and breakfasts not applicable here. Let me read that again. Residential land does not include any portion of the land that is used for any purpose that would cause the land to be otherwise classified. This dovetails exactly with what we have been saying. Mixed classification of a single parcel is proper only if there is a mixed use. Period. End of inquiry. No assessor shows up and says to a single parcel homeowner, you don't use all this land or you don't need all this land, so we're going to classify some of it as vacant.
Mr. Clayton, could that last sentence be referring to land used for commercial or agricultural purposes?
Yes.
Okay.
Indeed. And it's undisputed here there was no use of the Lannys' property for any purpose other than residential, both parcels. The second proposition of our syllogism is,
Let me ask you this, counsel.
Sure.
Whether you win or lose, does it depend upon the success of your first proposition?
no. There's a secondary argument I will address at the end of my prepared comments, or now if you prefer.
Nope, I'll wait for you.
The second proposition of the syllogism is the used as a unit element has the same meaning and requirements in the multi-parcel setting as the single parcel setting. There are three main sources of support for this proposition. First, the statutory language. A parcel of land and contiguous parcels of land under common ownership are grammatically interchangeable. All the language that follows the parcel language, including the used as a unit element, is the same, and it grammatically applies equally to both the single parcel and multi-parcel situations. There's no linguistic suggestion of a different used as a unit standard in the multi-parcel setting. Excuse me. Second, the Hogan decision, issued by a different panel of this court, agrees with this proposition. Hogan is not binding on this panel, but it is persuasive on this point. And third, the constitutional uniformity requirement is important here. If the Lonnie's 1 acre assemblage would be entitled to 100% residential classification as a single parcel, what would be the rational basis for a different result simply because they happen to own two parcels rather than one?
Counsel, before you go on, I should have jumped in a little bit earlier. You said that Hogan supports this part of your argument. Doesn't Rust stand in contrast to this part of your argument?
It does, and I'm going to come to Rust and Twilight Ridge momentarily. Just to conclude the uniformity argument, multi-parcel homeowners use their lands in the very same way that single-parcel homeowners do. That's no doubt why the General Assembly treated an assemblage of contiguous parcels under common ownership exactly the same as if it was a single parcel. We should not then construe the statute in a contrary manner in violation of the uniformity clause by treating these similarly situated homeowners differently. We acknowledge that other panels have disagreed with this point. Judge Vogt wrote the published opinion in Twilight Ridge versus La Plata County. Judge Ashby wrote the published opinion in Rust versus Summit County, rejecting the argument I just made.
And let me just let you know, it was pure luck or lack of luck that led to the two of us.
We didn't volunteer.
Yes, sitting on this panel.
I relish the challenge to persuade you. Obviously,
And we are open to hearing your arguments as to why we were wrong
well,
previously.
I would like to gingerly suggest that a different outcome is warranted here at least. In the Rust opinion, the panel was persuaded that the ARL imposes an additional requirement that an undeveloped subject parcel must be integral to the residence. The Rust case was tried in the BAA and decided on appeal without the benefit of the testimony of Kurt Settle of the DPT. Mr. Settle's testimony was admitted in this case, and it makes clear that the DPT does not intend for the word integral in the ARL to impose an additional requirement. Integral is just a synonym for the used as a unit element. If the panel in Rust had the benefit of Mr. Settle's testimony, that case might very well have come out differently.
You may recall, Mr. Clayton, that the panel in Twilight Ridge did have the benefit of Mr. Settle's testimony, and that he had testified that used as a unit requires more than simply incidental use. It requires integral use.
The transcript of his testimony in that case did not actually use the word incidental. I think that's an inference that the court drew, but is not actually the words that he used. And we have filed a cert petitions in both Rust and Twilight Ridge, and obviously time limitations today prohibit thorough discussion of those cases. But for anyone interested in reading more about our position on those cases, the cert petitions are a matter of public record, the court could take notice of that. The Rust opinion concluded, and I think Twilight implicitly agreed, that it's reasonable for the ARL to impose an additional requirement of integral use because single parcels are inherently unified, making an integral use requirement unnecessary in that situation. There's a certain logic to that, but that's not the approach the General Assembly took. The General Assembly decided that where there is contiguity and common ownership, that creates the sufficient unity to treat an assemblage exactly the same way as a single parcel. If the General Assembly had adopted that logic, we would have the word integral or some other requirement written into the statute.
Can I get clarification then on what you're saying right now? Are you saying then that with respect to multiple parcels, contiguity and common ownership alone would be sufficient?
Our first syllogistic argument is contiguity, common ownership, and the existence of a residence, which establishes a residential use, combined with no non-residential use, and that's always got to be assumed. I won't repeat it every time. No non-residential use means that 100% of the parcel or assemblage, as the case may be, is entitled to residential classification. I believe that the appellees would acknowledge that's absolutely, undisputedly the case in the single parcel situation. And all we're arguing is that, for the reasons I've articulated, the exact same approach must apply to a commonly owned contiguous assemblage.
So am I reading too much into this? Or under your theory, any vacant piece of land that is contiguous to a piece of land with a residence on it and under common ownership would automatically qualify for residential
Yes.
categorization?
Yes. And it's just like the Geierman and Farney cases, where a 36-acre parcel and a 300-acre parcel, 300 acres, this court had no problem saying if there's a residence and no non-residential use, the whole thing is entitled to residential classification. Now, our argument is, well, why does that logic not intuitively and textually apply to a 1-acre parcel that the, or 1-acre assemblage that the Lonnies have? Why does the mere fortuity that it's two parcels fundamentally change the analysis? There's no textual basis for that.
So are you then also saying that there can never be a classification of a lot as a vacant lot if it's contiguous to a residential lot and there's the same owner?
Contiguous common ownership, a residence, and no non-residential use, yes, it's automatic. Automatic 100%, just like the single parcel context. It should not feel, it doesn't feel to us like it's even a radical proposition. If the Farney family could have 100% residential classification for 300 acres, why is it so offensive? Why is it drawing these ad hominem attacks to say that the same thing should apply on a 1-acre assemblage that happens to be two parcels? I need to address Judge Daly's point because I'm running low on time already, and I promised I would. We have a secondary argument, which is this. If some additional affirmative use of the subject parcel is required, Judge Vogt, to your last question, if I'm wrong on the syllogism, and you've got to have some additional use of this subject parcel, it indisputably exists here. Look at this aerial image. This is from our opening brief. The aerial image of the two parcels outlined in yellow. Here's the house, here's the vacant parcel. Look, please, at the other photos in the record showing the ground level views from different perspectives. A house built on the subject parcel obviously, undeniably, would be highly visible and audible from the Lonnie's home. We have to use our common sense and our human experience here a little bit. The board did not find that the subject parcel provides no buffering or no view protection. They found only that development of the subject parcel would not significantly impact the view of the Gore Range. The board dodged the key issue under Geierman and Farney. Is there any use of the subject parcel in the slightest for view protection and buffering? The answer here is obviously yes. No reasonable person could deny that. Now, you might argue about the magnitude of it. You might say, oh, well, they have some buffering, as the assessor says, they have some buffering with forest land on the north side. All right, but come on. This family obviously is using that subject parcel to enhance their enjoyment of their home to some extent. That is a sufficient additional use, if any is required.
Well, let me ask you about that, counsel. Any use in the slightest, or you indicated just a minute ago, and yet that seems to go contrary to what the rust analysis was, and incidental use is not going to qualify.
It is contrary, respectfully, it's contrary to rust and twilight, and I can't reconcile them. I ask this court to consider the syllogism, consider Hogan, and consider whether a different approach is warranted. And I know the court, all members of the court approach this with an open mind. That's all I could possibly ask for.
Let me ask you one further question about Hogan. Hogan distinguished rust. It didn't decline to follow rust at all, did it?
Hogan preceded rust.
Okay, the rust distinguished Hogan then. Thank you.
I have 34 seconds. I'll save it for what it's worth. Thank you.
Good afternoon, and may it please the court. My name is Christina Hooper, and I'm an assistant county attorney for Eagle County, and I'm here today on behalf of the Eagle County appellees. My attorney registration number is 38271. Also at council table with me today is Ms. Katie Allison, counsel for the Board of Assessment Appeals, and she and I are sharing time today, so I'll do my best to give her time to present argument as well. The BAA order should be affirmed because it has a reasonable basis in law and is supported by substantial evidence in the record. The petitioner failed to establish that the unimproved lot was actually used as a unit in conjunction with the residential improvements for any of the tax year, and also failed to establish for 2014 and 2015 that it was under common ownership with the contiguous parcel.
May we stop the clock for one moment? And I apologize for interrupting, but I think I saw people coming in with coffee, and if they have coffee as opposed to water or something, if you could take those out, please. Sorry to interrupt.
No problem at all. Thank you. So the finding that the property was not actually used as a unit has substantial record support, and this court could affirm the BAA on that basis alone. Under our property tax code, a parcel that does not itself contain a dwelling unit can only receive residential classification if it's used in conjunction with residential improvements located on the contiguous commonly owned parcel. Petitioners claimed uses.
Was it your position that you needed a residentially improved building or structure on the contiguous parcel?
That is an interpretation that Eagle County has presented, and not in this case. This case, we focused on the issue of actual use. But if you look at the statutory text in connection with the Vail Associates case and the Colorado Constitution, I think that the Sullivan interpretation is correct, that the legislature intended that there be some sort of residential improvement, not itself a dwelling unit, on contiguous parcels in order to receive the residential classification. But assuming, for argument's sake in this case, that just a residential dwelling unit is required on the neighboring parcel, the parcel must itself, the vacant parcel or unimproved parcel, must be actually used as a unit. There must be a connected use between the two parcels.
Why isn't there a connected use if I'm looking out my window of my house across this vacant lot and trying to protect a view of the mountains? Why isn't that a use of the contiguous lot?
Well, I can answer that question in sort of a two-part answer. I think with respect to this very case, Mr. Lanny's testimony was that he needed and used the subject unimproved parcel to protect his view of the entire Gore Range, because a development of that neighboring parcel would occur directly in his view site of the entire Gore Range. When evidence was presented beyond Mr. Landy's testimony, we had both testimonial evidence from the assessor as well as direct evidence. Those assertions were discredited, and the BAA was within its fact-finding province to determine that the actual purpose for which the subject lot was said to have been employed by the petitioner in this case was not actually occurring. They could find that that was not actually a use happening on this particular parcel.
If they had found otherwise, if they had found that that's right, looking out the window was to preserve their use, would that have qualified as a use?
Well, the second part of second part of my answer to that question would directly relate to just hypothetically whether a view can qualify. And Eagle County's position is that it's not just the use, but you have to actually show that the use is as a unit in connection with that parcel. So that standard, I think, is higher than just saying, I have a parcel next door, I can look out my window and I enjoy looking at that parcel, therefore I am using that parcel.
I'm not looking at the parcel, I'm looking beyond the parcel, and I'm using that parcel to keep my view open of beyond that. Is that not using that contiguous lot?
It perhaps is. It's following the, I think, Twilight Ridge and Rust analysis of this issue. I think that type of use is probably an incidental use. It's probably more in line with peace and serenity that you may get from, or enjoyment of a property. In terms of it actually being a use as a unit, Eagle County's position is that that is a subjective, testable assertion of use that we assert is not what the legislature intended. If that's
how do we get to the point where an incidental use is not envisioned by the statute? Where is the qualifier in the statute?
The statute requires use as a unit, and this court in multiple contexts in terms of classification cases has repeated and confirmed that the characteristics of a parcel and the predominant actual use of the property on the assessment date are the considerations that an assessor needs to make and that are the relevant factors for a court reviewing that decision. In this case, and I would cite the O'Neill v. Conejos County case as of just 2017 for that proposition. In this case, the direct evidence that was presented was that the characteristics of this parcel is vacant land, and the predominant and actual use was to keep the parcel vacant. The facts, I think, are very important in this case. I think that the assertion that the property was used for recreation, for wildlife viewing, for maintenance of a single tree, and for this asserted view protection were all discredited by direct evidence, non-subjective assertions, but actual recorded documents, the plats, the covenants for the parcel that govern development of that parcel, the building envelopes, all of these things. And the board weighed that evidence and determined that they could find no connection between the two parcels that would actually show that they were being used together.
Can I ask you a question? You were talking about the assessment taking place as of the date that the assessor may have been out there looking at the property. So it's possible that the property could be reclassified if the assessor went out on a different date and observed different activity occurring and then testified as to what observations they had made and what connection there was between the subject and the residential parcel at that point?
Yes, and I think the ARL is instructive on this issue. It is incumbent on the assessor to go out and do physical inspections and obtain all information available, and I think that was presented to the BAA that indeed occurred here. And yes, if the assessor goes out and does visibly see or can find some connection between the two parcels, the assessment, the classification change would be made as of January 1st, the following year, because you have to look at how the property was being used as of the assessment date. In this case, I think assumption that these parcels are an assemblage is one of the major flaws in petitioner's argument. I think that petitioner's argument misinterprets both the Gehrman and the Farney cases. There is nothing in those cases that would indicate that, as a matter of law, some statement of enjoyment or just the connection of these parcels and no non-residential use occurring should, as a matter of law, dictate residential classification for a vacant lot. In fact, the court in both of those cases recognized that this is a question of fact for the Board of Assessment Appeals to determine. Again, assuming that these two parcels in this case were an assemblage or a unit and trying to apply Gehrman is erroneous. It's flawed. The evidence that was presented was that this parcel is actually separately platted. It has separate development rights, and it retains those separate development rights. The testimony of Ms. Noakes in this case for the county showed that the parcels were separated by a barrier of trees. One is landscaped one way, the other was left completely vacant and open. I think that interpretation of Gehrman and urging this court to adopt that standard, which we don't even think is the standard, but urging this court to so hold, and as petitioner argues in this case, would ignore the ARL. The Division of Property Taxation has been charged with the responsibility of interpreting these statutes, and that interpretation is entitled to deference. And that interpretation indeed sets forth factors that requires the fact finder to determine if these parcels are a unit or not just that they are next to each other and commonly owned. And we I would also argue that it contradicts the express language of the statute, because if the legislature only required the common ownership and contiguity and no non-residential use, the legislature would have said so. The subject parcel here is identical in character to two unimproved parcels directly east. Mr. Clayton showed you a aerial, and if you look, there are two vacant parcels directly to the east of the subject parcel. They're equally unused, and they remain vacant lots capable of future development. And without any actual difference in the character or use of those two parcels, petitioner asks you to reclassify or require the reclassification of the subject parcel, while the other two lot owners would be subject to the non-residential classification rate. And that result would violate the legislative directive at 39.1.101 to construe the provisions of the property tax code strictly in favor of the principles of just and uniform taxation. And it would result in a system where the subjective beliefs of property owners are dictating classification and not actual use. And it also sets up taxing entities for uncertainty, which we also do not believe is the intent of the legislature. So I ask the court to affirm the orders of the BAA because the property was not misclassified. The BAA's decisions here are supported by substantial and competent evidence and firmly based in the law. And I'd like to turn over the remainder of the time, if there are no further questions for me, to Ms. Allison. Thank you.
May it please the court, my name is Katie Allison, registration number 39430. I'm here today representing the Board of Assessment Appeals. The county is correct that the subject land in this case was properly classified as what it is, vacant land, because it was not used as a unit in conjunction with the residence, and it was not under common ownership. And I hope to address both the use and the ownership element if there's time, and I will try not to repeat. I first want to talk about use and the rust and twilight standards, which I think are absolutely correct. And they make sense because the purpose of these property tax statutes is to provide a modicum of tax relief to homeowners, and that's in the Vail Associates case. These uses for peace and serenity, for viewing wildlife, for looking at views, these are vacant land uses. They are a use of the property, a non-residential use of the property. They are vacant land uses of the property. They are using the land by keeping the land vacant. In addition, your question, Judge Daly, about the view, a view is a great way to enjoy the land, but a view is an entirely speculative use, as is seen in this case. We're talking about a residence that may or may not be built by some future owner, and we don't even know where. And that is not a use on the assessment date. Also, view is considered in these cases in the next context. We are talking about classification. In valuation, when you value the property after you've classified it, that's where the appraisers evaluate the view, and they put a monetary value on the view. In this case, we also have the claimed use of walking on the property and children playing on it. And I think Rust and Twilight are appropriate again in saying that those are occasional uses that are not sufficient. Also in this case, the petitioners didn't meet their burden. If any of these uses are considered sufficient, there is really no supporting evidence for any of the petitioner's claimed uses. We have that they mowed the lawn twice a year, but when you look at petitioner's own photographs, that lawn has not been mowed in years. There are dead plants on that lawn that cannot have been grown and died within the couple of months where they claim that they had mowed it. They claim that there's wildlife on the property. We have no pictures of wildlife. They claim there's children playing on the property. No pictures of children playing.
If there had been a swing set on the property, would that have been qualified as a sufficient use?
I think a swing set would be a really great example of something that could possibly be a sufficient use, and that would be where the BAA's credibility and fact-finding is important to see, was that swing set actually used? Was it put there for them to use that property? Yes.
What about, as long as we're hypotheticals here, they put some sod in on the vacant property after the taxation period at issue here, but had that been put in at the beginning of the period, is that a sufficient use of the property to make it used as a unit with the residential property?
Again, I don't think, I think this would be a good question for the BAA, right? If there's this elaborate landscaping on the subject property, I think yes, that could certainly qualify as a use. I see that I have no further time. We ask that you affirm the BAA.
Judge Daly, I was mistaken. Rust preceded Hogan. Hogan distinguished Rust. Twilight Ridge distinguished Hogan. If our syllogism argument is correct, all the distinguishing and factual distinctions become immaterial. That's part of the beauty of our position. It's simple, easy to administer, predictable and fair, and the taxpayers won't be tormented by the type of questions like, is a swing set good enough? Is the lawn good enough? Is extensive? And we have to ask the BAA in every case. Not a good situation. Thank you.
All right, thank you, counsel, for your arguments, and we will take them into consideration and issue an opinion in due course. Thank you.
Do you need a break? Do you need a break? Do you need a break?
All right, and it looks like council are at the tables and ready to proceed. Again, any questions about procedures for oral argument? And again, we are live streaming, so if there's any information you don't wish to be out there publicly, just be mindful of that. Okay, thank you.
May it please the court. My name is Elle Byram, registration number 50803. I represent mother in this matter. I'd like to reserve 2 minutes for rebuttal. Your Honors, there are 4 key issues in this matter. Whether the district court erred in not vacating the arbiter's awards because the arbiter, Ms. Sullivan, failed to hold a hearing within 14 days after she restricted mother's parenting time in violation of 1410-129-4. Second, whether the award should have been vacated because Ms. Sullivan improperly concluded father's email was a motion to restrict pursuant to 1410-129-4, when in fact no verified motion was filed. There was no reference made to 1410-129-4 in father's email, and there were not, facts sufficient to support a motion to restrict. Third, whether the award should have been vacated because the arbiter failed to hold mediation first when she issued any of the 3 awards following father's March 2nd email. And fourth, whether the June 18th award should have been vacated because Ms. Sullivan lost authority to rule upon the issue 3 months after father sent his email. Thus, the district court's order denying mother's motions to vacate the March 15th and April 18th award, and the district court's order confirming the June 18th award should be reversed because Ms. Sullivan's conduct in not holding a hearing, in finding that father had filed a motion to restrict, and failing to hold mediation first was both misconduct and exceeding her powers under the arbitration statutes.
Not to suggest that that's what happened in this case, but could a party who was opposed to an emergency motion, such as the father apparently filed here in early March, could a party prevent that from ever being granted by simply not responding?
No, I don't believe so. I think that the court would still set it for a hearing. A hearing's mandatory under the statute. And so even if the party didn't file a paper response to it, the court would still have a hearing. Now, if the party didn't show up to the hearing, that would be a different circumstance. Definitely not the case here. Mother did actually respond. Father sent his March 2nd email. Mother responded on March 5th, saying she didn't believe he had a basis to send that email. At this point in time, there's been no motion, no reference to 1410-129-4. It was on March 6th when Ms. Sullivan responded, and sua sponte said this was a motion to restrict. And the next day, March 7th, mother stated her opinion. Less than a week later, or about a week later, Ms. Sullivan issued an interim award. Nothing else happened.
Let me ask you, on March 6th or March 7th, did Ms. Sullivan provide mother with the opportunity to set or have some dates for a hearing?
The email exchanges, Ms. Sullivan's March 6th email asked mother for either her opinion or dates. She didn't ask father, who's the one who initiated the whole interaction. Father never responded. I don't believe that the person who's the lowest on the totem pole here should have been the one trying to provide dates. She could have just picked a date and set it.
And on March 7th, did mother actually ask to stay arbitration pending a district court ruling?
I believe, and I can't remember exactly the timing, but I believe she filed a motion a couple days later. I was not involved in the case at that point in time. When she filed a motion to stay, it was sometime, I believe, shortly after that, which the district court ultimately denied.
Why has she not waived the claim that the hearing should have been held within 14 days?
We objected the whole time. So I don't believe that that's been waived at all in this instance. So father sends his email March 2nd. Stating there's an emergency because there's difficult parenting time exchanges. March 5th, mother responds stating that she doesn't believe that he has the law basically on his side, referencing 129.1.5, which states that if there's been a motion within the past 2 years, that a parent can't change this, the primary time with the other parent, so you can't change the substantial parenting time. March 6th, Ms. Sullivan responds stating this is a motion to restrict pursuant to 129.4. But no verified motion was filed, no reference was made, and I don't believe that difficult parenting exchanges for 2 years constitutes imminent danger.
And you may be right, but at that point, Ms. Sullivan seemed to think that the issues may have raised an emergency motion and was asking Mother for some dates for a possible hearing, and the response appears to be, from the record, is, how about a motion for stay? How can you have a hearing at the same time when Mother's not providing a hearing date and asking to stay any further proceedings?
Well, I will state her email actually says your opinion or dates. Doesn't ask for both. There's this definitive or. Regardless, I don't think if you were to compare this with a district court, I think a district court would just set it for a hearing.
Yeah, and that may be right, but remember, arbitration and vacating arbitration awards or rulings are different than perhaps review of district court rulings. There may be more latitude given to the arbiter than, say, a district court judge.
There is a lot of, I would say very much that, based upon the case law, that there's a lot of deference given to arbitration awards. However, there's a few different things I think at play here. This argument is specifically looking at whether she exceeded her powers and whether it was misconduct to do what she did. And some of the Colorado courts, there's very little with regards to what constitutes misconduct under the statute. Knopfsinger is one of the primary cases, and misconduct under the statute is showing some sort of bias. In the Knopfsinger case, it specifically said that the arbiter had made a decision within the first 5 minutes, basically, is how they were describing it. It's not real clear how far into the proceedings, but the arbiter had made up his or her mind. In this case, I think it's very analogous to that, because she made up her mind to restrict Mother's time entirely on three email exchanges between the parties. Father's March 2nd email, Mother's March 5th response, and then Mother's March 7th response to the arbiter's March 6th email. And thus, she had her mind made up. She didn't actually hear or weigh testimony. There was never anything to do that. And so, yes, I believe that awards are given some deference, but here, when she's supposed to be applying Colorado law, that's what the arbitration agreement says. It's very clear that 129.4 and Slowinski, which is a seminal case here under 129.4, requires a hearing.
So,
Go ahead.
thank you. So your position is the misconduct is overt bias.
I think there's biases reflected, well, first off, so there's misconduct and there's exceeding powers. Exceeding powers is failing to follow the arbitration agreement. And that can mean ignoring the law. And I will specifically quote, there are quotes in her award. First off, her March 6th email, she very much recognizes that a hearing needed to happen. She states in there that needs to be a decision within 14 days, and then states the restriction continues until there's a hearing. And then more blatantly, in her award, she says, very specifically, a motion filed under this authority is self-executing and must be heard for a full evidentiary hearing within 14 days of the court, in paren arbiter, determines that there is sufficient evidence to allow the restriction to continue. And then she states, due to the tender age of the child, the severity of the allegations and concern for the child, the need for an expert assessment of the needs of this child, a hearing within 14 days is simply impossible to accomplish. There is nothing, there's no case that says an arbiter or a court can make a decision on a motion to restrict, based upon emails or because there isn't time, because there isn't evidence. In fact, I'd argue that if she's saying there isn't evidence, then she had to deny his motion to restrict.
Why isn't that an erroneous application of law, which is normally not a ground to set aside the arbitrator's award?
I guess I'm not quite following your point. An erroneous...
Why is it not simply an erroneous application of the law, which is normally insufficient to set aside an arbitrator's award?
I don't believe that this, I believe that this shows that she knew what it was. When you look at the case law interpreting what exceeding the powers are, it very specifically says that ignoring the law is something that is exceeding the powers. So the cases that say that are Korsburing, Giraldi, I believe some of the other ones that are cited in petitioner's brief and father's brief. And so there's a big distinction between somebody who just got it wrong versus somebody who knew what the law was but chose to disregard it. That's exceeding the powers, and that would allow the awards to be vacated.
Can I ask you a question? Obviously, the parties may disagree as to whether the facts in this case do or don't support a waiver, but is it your position that a party can waive the 14 days?
I don't believe you can. I have not seen anything that allows that to be waived. Granted, I haven't seen it applied in an arbitrator setting, but if an arbitrator is supposed to be applying Colorado law, which is the case here, then it says very clearly that it's 14 days. And the reason that Slowinski sets forth is it's a balance between potential endangerment to the child and the constitutional rights afforded to the parent whose time is restricted. And therefore, the parent whose time is restricted, if they don't have that hearing, you're essentially prejudicing that parent. And that's exactly what Slowinski says, is that father whose time was restricted past the 14 days, he was prejudiced because his rights with his child, his constitutional rights to parent his child the way he is allowed to under the Constitution, were restricted. And that's, I think, analogous here. She didn't have a hearing. She didn't have an opportunity to argue against what father's allegations were in his email, which was the entire basis for Ms. Sullivan's award. That's where the bias part comes in. That's where the misconduct comes in. It's misconduct because she didn't follow the law. She knew what the law was. She made up her mind entirely based upon his one email. I don't believe, getting back to the waiver issue, that it can be waived. I've seen nothing that says it. In fact, Slowinski interprets the statute to say it's mandatory. And the whole issue ends if a district court hasn't ruled on it in a hearing within 14 days. They lose authority. That's crystal clear in what Slowinski says interpreting the statute.
Can I ask you one other question, which is what, if any, impact you believe the paragraph in the arbitration agreement, paragraph 10, which says the arbitrator shall have sole discretion to determine the format for the arbitration hearing with the goal of expediting the hearing and facilitating the truth-seeking process. Do you believe that provision has any relevance to the issues we're addressing?
Not directly. I mean, the format to me means what room, how many chairs, how are people going to be set up. That doesn't mean that you can completely disregard the requirement of a law that says a hearing is mandatory. So no, I don't think that that has any bearing on it. She was to apply Colorado law, and Colorado says 129.4, and Slowinski interpreting it says that this is mandatory. I wanted to bring one more point before my time gets to my rebuttal time. One of the things, too, that to me shows the bias, the misconduct in this, she ordered the parties to go see Laura Forzan, who's a therapist. She called up Laura Forzan. To me, that's the equivalent of a district court judge calling up a joint expert. A district court judge would never call up a joint expert to ask the joint expert things outside of the court. The expert would come in and testify. The other thing that's stated that I think...
Where's that in the record that she called up Ms. Forzan?
It's in Ms. Forzan's report.
Okay.
So, and Ms. Forzan specifically states in a report, I want to find the quote, after my initial conversation with Magistrate Sullivan, I was extremely and pleasantly surprised to see the appropriate and loving interaction between mother and child. The only insinuation you can get from that is something negative must have been said. To me, that's pretty clear bias. If you're calling up the therapist who you ordered the parties to see, and that therapist is now pleasantly surprised because mom's actually having good involvement, something negative must have been said. And I will reserve my remaining time unless there's any additional questions.
May it please the court. My name is Alex Masterson, attorney registration 47970 for the appellee, Ramsey Lama. The primary question presented in this case appears to be whether the appellant's rights to due process were violated. The appellant, mother, was given the opportunity to participate, and she chose not to. Now, I intend to address the issue of due process primarily. If I have time, I will address the other points that do arise in Mother's brief.
I sure hope you will. I just heard a fairly spirited argument about bias and misconduct. I would hope you would address those.
I will, Your Honor. Mother's primary argument is that she was not afforded an in-person 14-day hearing within the 14-day period after father's emergency motion. Now, she couches her argument in Title 13, 1322-223. Now, at its core, Mother's argument is about due process related to this hearing. And at its core, the Slowinski case is also about due process. In the situation that the court faces here, the arbiter did send that email to mother that was just addressed in mother's counsel's argument. In that email, the arbiter noted that there could be an in-person hearing, offered mother that opportunity. She also mentioned the option of a phone conference, a conference call. And she further mentioned the option of mother simply responding with her position via email. Mother did not do any of those things.
Had an email exchange, would that have been enough to satisfy any statutory requirement regarding hearings on these motions?
I believe it would, Your Honor. In the context of arbitration, these matters, and this is something I was planning on getting to, these matters often occurred via email. The parties live in different cities, and the arbiter lives in Colorado Springs, mother in Salida and father in Canyon City. Business in this case often transpired via email, and I do believe that would satisfy that. Mother chose not to respond to the arbiter's offer. She didn't respond at all to the allegations that father made in the sense of providing her responsive position. What she did do in that time was file a motion to stay with the district court and inform the arbiter that she apparently filed a grievance against her with the Office of Attorney Regulation. How can a party complain for lack of due process if the party does not participate in the process that was afforded? And it's also important to note that the emails that were exchanged during this time followed the arbitration agreement, and they followed the arbiter's policies and procedures. The arbiter's policies and procedures are found at page 158 in the record, and this communication fit that to a T. Now, in addition to that issue of due process, mother claims that Colorado law was not applied. However, to the questions that were asked in mother's counsel's argument, the arbiter noted that Colorado law applies, both in her email notifying mother that she was treating father's email as an emergency motion, and in the resulting interim arbitration award. After that, it frankly does not matter the arbiter's interpretation of the law. That's supported by the Coors case. And one of the core tenets of the Colorado's Uniform Arbitration Act is that the merits of the arbitration award are not reviewable. Even 1322-223 explicitly states that it is not sufficient grounds to vacate an award because the relief in that award could not or would not be granted by trial court.
Now, you would agree that an arbiter's award can be set aside also based on bias, and I wonder if you would address opposing counsel's argument about the bias shown by Ms. Sullivan.
I will, Your Honor. Would you prefer that I...
Well, finish what you're doing now, but I don't want to...
Certainly. I will go ahead and address the bias. Mother claims that the arbiter was both biased and prejudiced against her. In her brief, one of the primary contentions of why the arbiter was biased against her, the record that she points to support this contention, is that the arbiter made a decision based on this chain of emails. That is not bias. Bias is an extraordinarily high standard to demonstrate, and mother cannot point to anything in the record that would demonstrate that the arbiter was inherently biased and prejudiced against her. She can't. There's nothing in the brief, there's nothing in the record that would support that direct contention.
What about what we just heard argued, and that is when she contacts Ms. Forzan seems to have a negative impression about mother or the child's reactions with the parents.
Your Honor, I believe that there are a multitude of reasons that there could have been a negative impression about the child's relationship with mother. It is inherent through the record of this case that there have been issues with that relationship, significant enough that the arbiter in this situation decided that it was sufficient to restrict mother's parenting time. And so the fact that the counselor, Ms. Forzan, had an impression of what the situation was, I don't believe that tells us anything. We don't know what was said or what wasn't said. And ultimately, when it comes down to Ms. Forzan's report, that's not indicative of whether or not the arbiter was biased against mother because there's no record of the conversation.
How about the arbiter's reaction to Ms. Forzan's report? Seemingly fairly and unequivocally negative.
Your Honor, my response to that would be that the arbiter is the sole arbiter of credibility in the context of arbitration. She makes the decisions and she knows the record of the case. And as I mentioned, if the court reviews the full record, things that are not necessarily relevant to this current appeal, there is a history in this case of serious problems between the child and mother and the relationship that existed there, in addition to mother's actions taken to alter the course of litigation.
Can I ask you to answer the question regarding whether you think the 14 days can be waived?
Your Honor, to answer the question directly, I don't know if it can be waived, but I believe in this situation, mother chose not to participate in the process.
Does a choice not to participate in the process affect the responsibility of the decision maker to act under the statute to determine whether there should or should not be a restriction imposed?
I would say that the choice of mother not to respond, let me answer the question this way. One of the key points of reasoning in Slowinski was that the failure to timely hold a hearing, in the sense of a district court answering these questions, the failure to timely hold a hearing infringes upon the parent's right to persuade the court that the restriction is not necessary. To me, that speaks directly to what happened here. Because mother was afforded that right, she did not respond to it. The arbiter was then left with a situation that she recognized and deemed as an emergency, and she saw as a danger to the child. She then acted.
Didn't the arbiter also decide within 14 or 15 days?
She did.
Yeah,
she
so
made a decision within the 14.
She had some kind of interim award, interim decision?
That's correct, Your Honor. It was called an interim award, and it was issued within that 14-day period.
But I guess my question is, the statute seems to require a hearing within the 14 days. So does the statute then, is it your position that it allows an extension of the 14 days to have a hearing? Because the statute itself requires that there be supervised visits within that time frame until the hearing is held, and the reason why there's the expedited time frame is in order not to stretch the restriction that may be imposed pursuant to the statute unnecessarily, for an unnecessarily lengthy period of time. And I guess that's one concern I have here is we're ultimately looking at the hearing really not happening for a couple months, even though there was an award issued by the arbiter before that.
My response to that, Your Honor, was that the proceeding that happened, granted it was via email, but the proceeding that occurred, the exchange that occurred between the arbiter and mother, sufficed in this situation to make that determination. The arbiter had context because, unlike the district court, the arbiter has been involved in this case for an extended period of time and has a little easier recollection of what's been going on. And as a result, when she made the determination that it was an emergency, she offered mother the opportunity to respond. When mother did not, the arbiter used that exchange. That was the substance of the hearing.
How do we construe then the arbiter's statement? We're now construing what she did pursuant to the emails as conducting the hearing, but she herself made the statement that she couldn't have a hearing within 14 days because she needed additional information and was going to actually have the hearing sometime after she was able to get that additional information. So I'm having trouble kind of getting all this to fit together.
I understand, Your Honor. So I would still say that that statement that was in the interim arbitration award regarding a hearing is gratuitous for the purpose of whether or not something was held in that first 14 days. The arbiter is referencing what eventually did happen, which was a full-on, in-person arbitration hearing after a period of time when there was some input from a third-party neutral expert. And the arbiter was able to accomplish that, but not immediately. But I do not believe that that changes the fact of what happened within that first 14-day period. The arbiter contacted Mother. Mother did not respond to the allegations. She said other things. And then the arbiter made a decision within that 14-day period. And I believe that that satisfies the statute, satisfies Solowinski.
Was either parent represented by counsel during this 14-day period in March? And if not, does that matter?
No, to my knowledge, they were not, Your Honor, not at this particular time. They've been represented on and off. Mother has been represented, I think, by 4 different attorneys and father by 2. And at this period of time, I don't believe they were represented, and I do not believe it makes a difference because they had been involved in this arbitration process for an extended period of time at this point. And they knew the procedures. They had been provided with them, as I referenced earlier, the arbiter's policies. And again, what occurred here was in accord with those policies. I would also point out that Mother ignored the primary method of obtaining review of this arbitration award in the district court.
Before you go into that, may I ask a question? I asked opposing counsel, what's the difference, was it only an erroneous application of the law? Her response was no. Mother showed that she knew the law and disregarded it. How would you respond to that?
Let me clarify, Your Honor. How would I respond to what Mother's counsel said?
Mother's counsel said that it was not simply an erroneous application of the law, the 14-day hearing thing. Mother knew what the law was and ignored it or disregarded it.
I think that would be absolutely incorrect, Your Honor. The arbiter noted the law, noted the statute, and she did make a decision, again, within that 14-day period. She sent the email. It was an email. It was not an in-person hearing. But she recognized the law, and she made a decision within that 14-day period. What happened after that was a continuation, but it does not negate what happened initially, including the fact that the arbiter notified Mother that this would be treated as an emergency motion under 1410-129, and then she proceeded to make decisions based on that. And my point about the part of this that Mother ignored is that she did not request a de novo hearing under 1410-128.5. The clarification in Rivera that the trial court has a special supervisory authority over arbitration awards that relate to children's issues is the de novo hearing. That is the sole method in the Uniform Dissolution of Marriage Act by which a party can request the district court review an award regarding issues that relate to the best interests of the children. Mother did not file for a hearing on the March award. She did not request a hearing for the April award. When she finally requested a hearing for the June award, the trial court denied it, and she did not raise it in this appeal. That is the primary method by which a party may request a review of this, the parenting decisions in an arbitration award, and she totally ignored it.
So I think this resolves then one point that was made in the opening brief, namely that the district court could have disagreed with the arbiter on the basis of the best interests of the child and somehow changed the result at that point. You're saying without a hearing, it couldn't do that?
Not unless it found under Title 13 that one of those 5 provisions is met. And as I mentioned earlier, Mother cannot point to any demonstrable bias or prejudice in the record. And if the court did not find that, the only other method to review this arbitration award is 1410-128.5 and the de novo hearing that's provided there. And I would add also, in my last 10 seconds, that the merits of an award are not reviewable under Title 13. You have to meet one of those provisions, and Mother has not met her burden of proof. So I would ask that this court affirm the trial court's orders. And I believe I'm out of time.
A few points in my remaining minute and a half, roughly. There's been a lot of stuff stated about Mother not responding, and I want to make it very clear for the record. Mother did respond. Her first email, which was prior to Ms. Sullivan's email, said aside from the request being without merit and barred by statute, she doesn't get into the details there, but then Ms. Sullivan sent her email on March 6th requesting for either an email or the dates. And then on March 7th, Mother responded and says, I strongly object to this emergency motion filed by Mr. Lama I do agree that we have serious issues with transitioning our son from one parent to the other. My desire is to work with Mr. Lama, and she goes into other statements. She absolutely did respond. Regardless of whether she responded or not, as I've said, I don't believe it can be waived just because somebody doesn't file an opposing motion. The court still sets it for a hearing. You go in, you present evidence. That's how it ends up getting resolved, not via emails. I will also state, he made the statement that a lot of stuff in this was conducted via email. All of the mediations and ultimate arbitrations in this matter were conducted via hearings and in-person meetings. There was never decisions made via just email alone. He also makes reference to bias as a high standard. I have yet to see any cases that set forth exactly what standard bias, what standard there is for that. In fact, the case law, as I mentioned, with regards to misconduct, is really thin in Colorado, and the only case that I really found that addressed it was the Knopfsinger case, which I mentioned before. I also wanted to just mention in my last few seconds, in this matter, and I do think this matters, father is an attorney. He's also a judge. My client is not. Therefore, he knew how to file motions. He knew what statutes were. Therefore, I request that the court reverse the district court's orders. Thank you.
All right, thank you, counsel, for your arguments, and we will issue an opinion in due course.